All right, hey everybody. I've got a kind of a neat little presentation today. Yes, I've reverted back to my first sergeant days, and I've created a PowerPoint presentation. Sorry, but the reason I did that is because I wanted to make sure that if you guys wanted to take screenshots instead of just listening to me, then you would be able to do that because there's a lot of information here that I'm going to be sharing, and I want to make sure that you get it out. And I wanted to put it down in writing as well. So here is before I do that, though, I wanted to share with you. I just created a new. Where is it? Apparently, it says an error occurred. Okay, never mind. Next time, I do have a new. Let me change this here. I do have a new sort of video intro that I made. You can see that on my Facebook law firm page. But today is actually going to be a legal issue. So the reason I decided to create this PowerPoint is because I've already had a couple of clients that I've had to help get out of a mental facility because for whatever reason they were put in there. All right. And there are reasons for that. Now, I'm not going to go into individual cases. I'm not going to talk about what the issues were. I'm just going to say that what you can do if this happens to you. That's the whole point of this video. So, yep, that's it. PowerPoints. It's going to happen. Greg, suck it up and just sit down and you're going to watch. Okay. All right. So anyway, this is kind of what we're going to be talking about today. Let me do this here. Is emergency detention orders. And just so you know, the emergency detention orders are in Texas anyway, are in chapter 573 of the Health and Safety Code. Okay. So everything that I'm about to tell you is from chapter 573 of the the Health and Safety Code. And I'm not going through the entire chapter 573 because some of it's pretty intuitive and self-explanatory. But what's important to know is a lot of people think that there's a 72-hour rule as it relates to involuntary detentions at a mental facility or hospital. And I'm specifically talking about mental health. In Texas, that is not the case. Now, there is historically, and I guess under the common law, there was a 72-hour rule where you could be held against your will for up to 72 hours pending an evaluation. But that is not the case here in Texas. And I'm going to try and tell you what the law is here in Texas. So first and foremost, oh, hello. What the heck just happened there? All right, there we go. First and foremost, what is it? What happens? There's two ways essentially for you to be committed. Those two ways are, and by the way, I don't think I can see. Let me see if I can make this to where I can see the chat. There we go. And that is one, a law enforcement officer, of course, because law enforcement know better than everybody about everything, right? So that is one of the ways. The other way is like a family member can have you committed or put into a hospital. And I have had one of each. So I've seen it from both sides. And I will tell you that the family member, after going through this process, absolutely regretted it. Okay. Because the family member called the police and the other individual was taken by the police to a hospital and then held against that person's will. And I'm not even going to say if it's a male or female. So those are the two ways essentially. And here's what it takes to get to be apprehended without a warrant by a peace officer. Okay. Now, obviously, if they go and get a warrant, that's a whole new thing. I'm not talking about warrants. I'm talking about you are being sent against your will right now because of something that you allegedly did or are doing. So here's the criteria for them to get you without a warrant. You have to meet this criteria. First, you have to be a person with a mental illness. Guess what? That could be anything. there really isn't a definition that is hammered down on what is a mental illness. Liberalism is a mental illness, but that doesn't mean that you can just throw, every Democrat or even most Republicans into a facility, even though we'd probably all be safer because of that. They must also have a substantial risk of serious harm to themselves or to others. So those two things have to be there, and there can't be time to obtain a warrant. So if there's time to obtain a warrant, in other words, the person's not an immediate risk, then you can't emergency detain someone. If they have a mental illness, but they're not really a risk of serious harm to anybody, then that is not going to allow you to arrest them without a warrant. You're going to have to go and get a warrant. Now, how is that substantial risk determined? Well, it's determined by the person's behavior, their acts, the things that they're doing, threats that they've made, statements they've made, or evidence of a severe emotional distress and deterioration of their mental state. Again, these are coming straight out of the code. That's why it's worded this way. I want you to know kind of what that means. Now, behavior is not really defined too well. I'm going to get into it a little bit more later. But when we talk about mental state, but once you are being picked up, as you're being picked up, you as the individual are required to be informed of the reason for the detention, right? You have to be told why you're being taken to a hospital or wherever you're being taken. I'm going to get a little bit more into that, what your rights are later. But you have to be informed the reason of the detention. They can't just pick you up and throw you in and say it's for your own good. Okay, that's not a good reason. And they also must be informed. Don't worry, there shouldn't be any conversation, by the way. I mean, once you're picked up against your will, and I'm going to explain why this is important later, and you'll see it. Obviously, make it very clear that you don't consent to being taken. You don't consent to any of this. You feel fine, make all that stuff known. But once it's look, I'm going hands on you. If you don't get in this car, it's almost like if you don't move, I will arrest you. Okay, now your rights have been violated. Go ahead and move unless you're willing to risk the arrest and all that. But for the most part, and I'll tell you why, once it's pretty obvious that you're going to be taken, just essentially go. But make sure it's clear you don't want to go, and ask what's going to happen if I don't go. And, they're going to say something like, well, I'm going to take you against your will anyway. They have to tell you why, and then they have to tell you someone is going to advise you of your rights within 24 hours. All right. Because the rights are a little bit different than like Miranda rights. Okay. This isn't a criminal issue. So Miranda rights don't apply here. There's a whole different set of rights that apply. And different constitutional rights. So don't expect Miranda rights. It's essentially the rights that have been coded in for this specific thing. Now, when someone's requesting an emergency detention order, there's a paper that they've got to fill out. And the code, again, it's 573 of the Health and Safety Code, actually has a generic, hey, this is what it's supposed to say. But this is what it's got to include. This is what the officer or the family member must fill out for the hospital in order for the hospital to accept them. The application must say that this person evidences mental illness. It must say that this person evidence also a substantial risk of serious harm to himself or others, and that harm is imminent unless this person is immediately restrained. Then it must also state that my belief for the above is derived from, and you've got to be specific. This letter, and this is where these things first start to break up. It's got to list specific behavior, overt acts, attempts like suicide attempts, or threats to do harm to self and others, things like that. There has to be something. You can't just say the person's a risk and they've got mental illness. Okay, well, where do you get that belief from? They've got to dictate that, and they got to be specific, and then just detail that behavior. And then, of course, the relationship to the person being detained, if it's a family member specifically. So here's the application process. You cannot be held more than 48 hours without an EDO, an emergency detention order. You cannot be held more than 48 hours. Now, this includes the time that you're waiting just to be processed into the facility. So the minute you arrive, the clock is ticking. The 48-hour clock is ticking. Now, here's the kicker. Weekends and holidays, they don't count. If you are taken into a facility on a Thursday evening, one of my clients was taken in on a Thursday evening, that 48 hours is going to fall on a Saturday. Well, guess what that means? That means that the 48 hours, their 48-hour timeline doesn't end until 4 p.m. on Monday, unless Monday is not a business day. For example, New Year's, Christmas, something like that. If it's not a business day, then now you're staying from Thursday to Tuesday. So that's what that 48 hours is. You've got 48 hours that they can hold you without an application for an emergency detention. Now, that doesn't mean that it's got to be approved, but they have to file that application within 48 hours. And let me tell you something. On one case, I almost got this, and literally it was within an hour of that 48 hours that it was filed. It was like at 3:15 on the day that they had until 4 o'clock, or maybe it was even 3:45. They had 15 minutes left. I can't remember. Either way, it was within an hour of that 48 hours. And believe me, they love taking their time. Oh, we've got 48 hours. Okay, but do you really need to wait 47 hours before you do this? And not only that, you have 12 hours for, and we're talking about the medical professionals now at this point. So we're talking about, you've already been admitted. The police are no longer involved. You're now under the care of a mental facility. And in my 2 cases that I've had so far, one was in a civilian center, one was at the VA. But just so you know, the VA follows state law when it comes to emergency detention orders. So they follow Texas law, and they have to comply with Texas law to hold you at a VA located within the Texas border. Now, they have to do a preliminary examination of you within 12 hours of being apprehended, or the moment that you're transported to a facility. So in other words, if your family takes you to a facility, that's when the 12 hours starts that you've got to be examined. And if you're apprehended by law enforcement, then it starts the moment you're apprehended. All right. So now what happens? This is kind of jumping ahead, but we're going to go back. But what happens after your preliminary examination? If after the preliminary examination or the 48-hour period expires, what are they supposed to do to you? Well, they have to take you back to the location where you were apprehended. They have to take you to your residence if you were at your residence, or quote, another suitable location. What does that mean? Who knows? I haven't really seen anywhere where this was litigated. I couldn't find where someone sued because they weren't taken to a suitable location. So who knows? But this does not apply if you've been arrested for a crime and also you're being sent for medical care, right? But generally, once you're done with your medical facility, you're probably going to jail anyway, once they release you from medical. But let's just say while you're in the medical hold, they drop all the charges against you. Well, since you were arrested, literally the medical people can just drop you off at the front door and say, see ya, you're out because you were arrested. Also, this is why I said don't refuse transport. If you refuse transport, they can do that also. They can just drop you off at the door of the hospital. They can drop you off at the gate to the VA and say, you're on your own, buddy. So if you're arrested or you refuse transport, you can kind of be screwed. Now, this is the important part because this is where I come in, and we're talking about the rights of a person who is detained. And you have to be advised of these. Now, what I have typically found, and I don't really like this process, is that people are read their rights in the middle of their crisis. And really, they're handed a sheet of paper and said, here, sign this. This is your rights. That's not the way the law reads. Okay, they're not supposed to just hand you a piece of paper, because what's happening is as you're being processed, you're signing all kinds of papers. All right. And you need to make sure that you read what you're signing. But one of those papers is generally going to be your statement of rights. And you have a right in the law to be advised of where you're being detained. So they can't just like blindfold you and take you to some, psycho ward. They have to tell you where you're going. They again have to give you the reason for the detention, and they have to advise you. And this is what they also don't do. And I'm going to tell you why this is important, incredibly important. They are required to tell you, even though they provide it to you. They say, oh, well, you signed the piece of paper. And I'll get to that in just a second. But how these rights are supposed to be communicated to you. But anything you say to a doctor or a nurse or a staff member while you are on an emergency detention hold, whether it's the 48 hours or longer, can be used against you in any proceeding. And this is important because I've had clients that, of course, they're pissed off because they sought help, and by seeking help, it led to an emergency detention. And now they're pissed off because they're like, look, I came in here of my own free will, and now you're telling me I can't leave? If I'm sane enough to come in here and recognize that I've got problems, I'm sane enough to leave and recognize that I'm okay, or I don't need your kind of help. But if you go in there and you start screaming and yelling at everybody and saying, I hate you and this and that, and you're you piece of shit, and this is, and you're just causing problems, and you're refusing to do things, and you're not taking care of yourself, all of that is going to be used against you. Look, when you get into this facility, okay, you need to be on your best behavior. And if you're mentally ill, that's obviously, for you, what does your best behavior look like? But you don't want to be causing problems while you're in there. You don't want to start fights with staff. You don't want to start fights with other patients. You don't want to say stupid things. You don't want to scream and yell at people over little itty bitty things. Yes, just like Crap Metro Observer says, do not trust the government for your healthcare. Absolutely. So you need to understand that anything that you tell them is going to be used or can be used against you. Okay. And this is important because I had a client who was legitimately pissed off about the whole process and did not want to be there. The person sought help. A veteran sought help because he saw that he needed help and ended up in this emergency detention. And then it was just nonsense from there. It was the entire thing, because this next point here, you have a right to communicate with and retain an attorney. You have a right to communicate with and retain an attorney. In literally each case that I had where I was hired to represent somebody, not only did I have to pull teeth to find out when their hearing was for their EDO, because look, this is how the system propagates itself. Okay. And I'm not saying that this is every single case, but in each case where I had a client, that client had several other people talk to me on the phone. And so I know that this is a pervasive issue, at least here in Texas. And by the way, these are, like I said, one was a civilian institution, one was a VA institution, one was in a big city, one was in a small town. So that tells me that this isn't like an isolated issue. This is a systemic issue. Not only was it pulling teeth for them to be able to contact me, their attorney, it was pulling teeth for me to find out about, I literally would find out about a hearing the night before. And in one case, the court closed at like 3:00 in the afternoon, and I didn't find out about all this stuff until it was like 3:50. And I'm trying to get a hold of the court and find out where this hearing is the next day. And I'm calling the hospital and like, oh yeah, he's got a hearing tomorrow. I'm like, well, where is it? Oh, it's virtual. Okay. How do I get on virtual? Well, you can't. Well, then how am I there with my client? Well, you've got to get special permission. And I'm like, excuse me, have you not read the 8th Amendment? Have you not read 372 of the Health and Safety Code? They have a right to communicate with and retain an attorney. I have this underlined and in bold because they don't get it. They don't get it. There is an entire machine of funding that goes into these mental health holds. And if an attorney shows up, it completely puts a cog, it puts a wrench in their cogs of this machine, because now they have to actually do their jobs. So I showed up at my first, I just showed up, and of course everyone's like, "What are you here for?" "Oh, we've never have attorneys coming here." And I'm like, "What do you mean you never have?" "Yeah, we never have attorneys. There's a court appointed attorney." And here's the other kicker. I showed up and I spoke to, because I literally just had to show up because my client told me about when the hearing was. So I made sure I was over an hour earlier than that. And I show up and I explain, I'm this person's attorney. "Oh, no, sir. He's got a court appointed attorney." I'm like, what? Well, that might be the case, but she's entitled to her own attorney. But the patient's already got a court appointed attorney. I don't give a shit who the patient has or what the court appointed. I am the patient's attorney, and I will be there unless you're going to violate my client's 8th Amendment rights. And it becomes, every single time, it becomes, I guess you could say, for lack of a better term, it's, a dick measuring contest. Who's going to be the bigger dick? And believe me, I can be a really big dick for having never mind. I won't go there. In the other case I went to, the same thing. Oh, and by the way, I show up at the hearing and there's the court appointed attorney because these are all done virtually, at least they have been in my experience so far. They've been, they're all kind of virtual. Like the court just zooms in the patients into this hearing, and on the hearing is the court appointed attorney. Well, guess what? In both cases where I had a client, in both cases, the attorney did not at any time prior to that hearing speak with my client or his client, his alleged client. Now, how do you go to a hearing? The hearing is designed to keep someone beyond the 48-hour period. That's what the detention hearing is about. It's about keeping them beyond the statutory period. Okay. Now, keep in mind also, this 48-hour period is just when they have to file the application. It might still be a day or two or a couple days after that. Like, here's a good example. Wednesday evening, you are brought in, right? Friday afternoon Friday evening would be the 48 hours, but that afternoon, they file the application for an emergency detention order at, 4:50 p.m. Well, guess what? They're not going to have a hearing that day. So now you just bought yourself an extra 3 days, because you've got at the earliest, the earliest hearing you're going to get is the following Monday, because they don't do these hearings on Saturdays and Sundays. So you've got court appointed attorneys who are supposed to go into these hearings on emergency detentions. It's a detention hearing. It's a commitment hearing is really what it is. And they've not spoken to the client. They haven't. How are you going to represent the interests of a person who's being held against their will and you never speak to the client? The first time you see that client is on that video screen when a judge or the doctors are saying, we need to keep this person because we'll lose money. I mean, we need to keep this person because it's in their best interests. How is an attorney supposed to argue their client's best interests if they haven't spoken to them? On my second case, I showed up and I'd spoken to him on the phone, but I'd literally gone to the VA the day before. And my client had called the police. The police were there. I explained to the police, hey, wait a minute. If the police are there and my client's there, I have a right to be there with my client. I realized he called, but if the police are going to be questioning him, I have a right to be there, especially if this escalates into something. Needless to say, I was never able to meet with him. So I went to the patient advocate, and this whole rigmarole. And I'm trying to find out when is the flipping hearing the next day. And nobody can tell me, well, if you're here at about 6:45, we don't really know what time it starts. We think it starts at 7, or generally it starts at 7. But I'm like, wait a minute, the specialty court doesn't even open until 8. So sure enough, that's how this thing works. About 7:30. So I'm finally able to talk to my client about 30 minutes prior to the hearing. Now, thankfully, both of these people I knew personally anyway. So it's not like I really needed a lot of information from them, because I knew their circumstances. I knew what was going on. I was speaking to the family, or I was speaking to the individual themselves. But how the hell can a judge, and this is the problem I have. So I get there and I explain to the nurse, because the nurse is checking me in, oh, okay, we got special permission. And I'm like, and I keep telling them, I'm like, look, I want to make very clear to you, you didn't get special permission for me to meet with my client. Okay. The 8th Amendment gives me permission to meet with my client. And if you don't want to believe in the Constitution, the Health and Safety Code gives me permission to meet with my client. Okay. Period. Full stop. This idea of special permission. And then I say, oh, by the way, while you're checking me in, this is my witness. What? Witness? Yeah, I have a witness. But this is not a criminal hearing. I realize that. This is a commitment hearing. This is a hearing to take away my client's freedom and liberty. This is a hearing to keep my client against his will in a hospital, in a room. This is a hearing to determine whether or not my client is going to be home to see his family. What do you mean? Why do you have a witness? So I show up at these hearings. Of course, I've got to, explain that I'm this person's attorney, not the person on the camera. And go in there, and thankfully, in both cases, in the first case, they wanted to keep my client for 90 days. They wanted to keep my client for 90 days. And I got it to where, because this was a medication issue, that she only had to stay 3 days, and that was only to ensure that the medications that the person was on were not going to cause problems or side effects, because the patient was getting different medications. So that was a win in my case, because they were trying to keep her for 90 days. I got her out in 3 days. The second one wanted to keep him for 45 days. I got him released immediately. No probable cause whatsoever. Because this whole communicate with and retain an attorney. That's why I spent a lot of time on this slide, because you need to understand, when you're committed or you're taken in on an EDO, an emergency detention order, or even just a warrantless arrest for mental health, the first things you need to be doing is, I want to talk to my attorney. I want to talk to my attorney. I want to talk to my attorney. Okay. You have that right. They're supposed to tell you that is your right. They have to tell you about the transportation. We already covered transportation on what happens when you're released. They have to release you after the preliminary exam, unless, and if the preliminary exam is done within an hour of you getting there, and they do the preliminary examination, unless they meet those previous criteria, they have to release you after the preliminary exam, unless you are determined to be mentally ill and a danger to everyone else. Now, here's what they do. Of course, they always say, yes, the person's mentally ill. Yes, the person is a danger to himself, herself, and or others. And yes, this person needs to be kept here. Why? Money. It's about money. So I put a little asterisk there, because, it really depends. Now, here's the thing. If you're being a prick and you're causing problems when you get in there and they haven't done the preliminary exam, because I saw this, they even told me, that my client allegedly assaulted someone. By the way, that didn't happen. And it's going to be used during the hearing. Like, okay, whatever. So anything you do and say might affect your preliminary exam, you know, because the nurses are going to tell that doctor when that doctor comes in, oh, he or she did this, that, and the other. And then you also, while you're in there, you have a right to reasonable communications with your relatives or another responsible person, you know, a wife, a friend, whomever it is. Okay. Now, here's where I told you about these rights, right? And I told you what I've seen happen, what my experience is they hand the patient a piece of paper and say, sign here, these are your rights, and then they're done with it. Here's what the law says. The rights must be provided orally in simple, non-technical terms within 24 hours of being admitted and in writing. Not or in writing, and in writing. The or here is only for hearing or visually impaired persons. If a person is hearing impaired, obviously oral is not going to help you. And if the person's blind, writing's not going to help unless you're able to do it in Braille. So absent a hearing or visual impairment, it must be oral and in writing. Oral and in writing. They can't just hand you a piece of paper, but yet that's what they always do. That is the presentation for EDOs. And I know it's short, but I want you to know that there's a problem, because here's what happened my second one. And this is why I decided, okay, I need to do a video on this, because this is just BS. So I showed up, I explained that, look, I have a right to meet with my client prior to this hearing. Okay. I need to present a defense to my client prior to this hearing. And if you don't give me access to my client, I can't present a defense. And so the nurse comes back and the nurse is like, well, we might have to reschedule so that you have an opportunity and some time to meet with your clients before the hearing. I said, whoa, okay, listen. If you're talking about rescheduling from now until like this afternoon, okay, let's do that, because I would like to sit and meet with my client. If you're talking about we have to reschedule a different day, I'll go in there blind and defend my client. I'll figure it out. I'll make it work. But no, we are not. I'm not keeping my client in here any longer than I have to. And I get in there and they're scrambling. They're scrambling because, oh crap, because they've never, literally, this is what she told me. We have never had, they don't even know what to do when there's an attorney involved. They have no procedure or policy for what to do when an attorney is involved, despite the fact that you have that right. It's on the piece of fucking paper they give you that you have a right to an attorney. And yet they don't have a policy for what to do when an attorney shows up. And and this is the problem. The problem is that I'm the first attorney to show up. Now, there's one of two reasons for that. Either people can't afford an attorney and don't have an attorney, or they don't know that they're allowed to have an attorney. Or they're told, as is in the case in both of mine, oh, don't worry, you've been appointed a court-appointed attorney, right? And like most court-appointed attorneys, you don't see that attorney until you show up for trial or you show up for a hearing. I cannot tell you how many cases I get substituted in on criminal cases where the case has been going on for over a year and they haven't spoken to their attorney yet. And then the first time they speak to him is at a hearing, and that's when they realize, I've got a dirt bag for an attorney. I need to find CJ. And it's sad. It's pathetic, but I don't want you, the viewers of this, to be ignorant about what your rights are. So 2 things. 1, demand an attorney. 2, shut up unless it's going to help you. Okay. Say good things, do good things. Don't lie. I mean, if saying something is going to hurt you, don't say anything. Obviously, if you need help, get help. But sometimes being, for example, for one of my clients, well, actually for both, being in that environment is not helpful. Being in that environment makes things worse. And what's interesting is I read the certificate, right? So when I went in there for the second hearing, I get a copy of the certificate. Now, in the first hearing, I was able to get a copy of everything prior. But I get there to the hearing and I, introduce myself to the judge, and the judge says, "Have you had a chance to review all the documents?" I said, "Your Honor, I haven't even had a chance to talk to my client. I have been trying to get a hold of my client and get a meeting with my client since yesterday. I haven't gotten any documents. I haven't gotten any certificates. I haven't seen any orders. I don't know what's going on here." And I know that the certificates are short. So I'm like, so he says, "Well, do you need how much time do you need to review all the documents?" I said, "I don't need more than an hour, Your Honor. All I need is an hour, review the documents. I can skim the stuff really quick, find out what they're using to try and keep him, and then I can determine whether or not, or what kind of defense I need to make for my client." And in this case, because they expect that they're not going to have any opposition, this is essentially just a rubber stamp process for most people, because no attorney comes in. The court-appointed attorney just sits there, and I don't even know what the court-appointed attorneys do, because I've never had to listen to one. But I can't imagine them putting up any defense saying, "Well, Your Honor, I don't think he should be incarcerated because he's got no argument. He doesn't know the client. He hasn't spoken to the client and has no idea even what they're in for other than what's written on the police report, the intake form, and the doctor's report." And again, I'm not talking about, at the end of the show, I'll tell you, if you do want to retain me, that's not what this is about. But if you do want to retain me, I'll tell you at the end of this. You just go to my website, cjgrisham.com, fill out the contact form. But it's a rubber stamp process when I'm looking at this certificate that a doctor fills out that is required. Remember, it's required to have all of these things on it. Okay. This is what that document is supposed to have, the certificate. It's supposed to have: person evidences mental illness, person evidences substantial risk of serious harm, risk of harm is imminent unless restrained, blah, blah, blah. But the beliefs must be derived from specific behavior. And what they have is they have a form with little check boxes on it, right? And you check off the evidence is mental illness. You check off is a substantial risk of serious harm to others. You check off that risk of harm is imminent unless he's immediately restrained. And then it's got little numbered blanks, right? 1, 2, 3, and then it's got something else, and then 1, 2, 3. And in one of the cases, literally, this is what the doctor used as a reason to believe, right, that my client was a serious risk of harm to himself and others. My client said, "Are you a Christian? I don't want to talk to you if you're not a Christian." That's the quote that the doctor used to justify his detention. What was the other one? Refused or asked to be released. He signed a against, it's called an ADA, against doctor's advice, or AMA, against medical advice. He signed an AMA that said, "I realize the doctors want to keep me here, but I'm good. I want to go home." Literally, those are the only things that the doctor included under this requirement. Beliefs must be derived from specific behavior and have a detailed description of said behavior. Literally, what was the said behavior in this case? The said behavior was my client didn't want to talk to a doctor who wasn't a Christian, and he signed an AMA because he wanted to be released. And he came in voluntarily. He wanted to leave voluntarily. So, of course, I argued, and while I'm with my first witness, by the way, because I called 2 witnesses, While I'm with my first witness, they were scrambling on the phone. You could see him outside the window, scrambling on the phone. And I asked the lady, because I knew what they were doing. I said, are the doctors normally here for this? Oh, no, they're not. So the doctor that is trying to incarcerate people for extended periods of time is going to take away their liberty, but he doesn't show up at these hearings to explain why. Interesting. But in this case, they got the doctor in there literally while I was cross-examining my second, or not cross-examining because it was my witness. While I was examining my first or second witness, the doctor walks in. So I'm done. I've made my point that my client is not psychotic, and that none of the elements that you see here on your screen right now applied in this case. They didn't have any of those. They all it was a conclusory statement. The person's mentally ill and is a serious risk of harm to others, but yet nothing in the documents explained exactly what my client did. Was he upset? I mean, hell, they could have even put something like, oh, he was screaming and yelling because he didn't want to be there. I mean, at least that would at least somehow explain mentally where my client was, but that wasn't even there. So I get ready, the doctor comes in, I'm like, oh, this is awesome. So after my second, I could tell, this is going a little longer than the judge is used to. And he's like, do you have any other witnesses? I said, well, Your Honor, is the court going to call the doctor? Because I would like to cross-examine these documents, because it's hearsay unless I cross-examine them. The person who wrote the documents needs to justify the document. Otherwise, the document itself, you can't even admit it into a hearing because it's inadmissible, because it's hearsay, unless the doctor's there to say, yes, I wrote this. Yes, these are my thoughts, and here's why. And thankfully, the judge agreed with me before I even had to do that, to call the doctor, because he's like, yeah, you can call the doctor, but I'll tell you right now, I don't find probable cause for any further detention. I said, well, in that case, Your Honor, I rest my case. And then he says, I'm going to find no probable cause and order the immediate release of so-and-so. All right. That's why it's important, ladies and gentlemen. It is important to communicate with and retain an attorney, because if you are committed, just like Slim Jim just said, there go your gun rights. There go your gun rights. All kinds of federal stuff gets queued in, and then now you've got a giant headache. And do I think that this is all about disarming people? I think some people, that's probably the case. Disarm as many people as possible. But in this case, he was never involuntarily committed. Neither of them. It's just they didn't want to voluntarily stay, was the difference. So long story short, if you've got a family member who's exhibiting, signs of a mental decline, or they're having issues. I mean, look, as a soldier, I get it. You get worried sometimes, and we soldiers say stupid things all the time, but take them to a doctor, take them to a psychologist, a psychiatrist, take them to their doctor, take them to a friend, take them to a meeting, go sit with them, spend some time with them, just try to calm them down, get them back in. And if they have to get help, then take them to get help at a hospital. Not at not at a hospital, at an actual psychologist or a psychiatrist. Don't take them to a hospital, because you know what the hospital is going to do? They're going to say, oh, we need to keep you here, because most hospitals are dealing with physical injuries, not mental injuries. All right, so I'm going to answer a couple of questions here. CJ, you got your license? Yes, I did. I am licensed. I have my own firm. As you can see, this is my law logo. If you would like to put me on a retainer, I do have, because some people have asked, somebody said, how do I get you on a retainer? I do have what I call a general representation retainer, and it's a $500 retainer that essentially it's 5 hours. And see, even for this kind of general retainer, I only charge $100 an hour on that retainer. If you have to make a phone call, hey, I just got pulled over, what do I do? Hey, I'm getting arrested, can you start working on getting me out of here? And then I can at least work on getting you out of there for 5 hours. And then we got to file, do a new contract on whatever the criminal case is. But it's a $500 general representation so that you can have the right to call me and say, I want to talk to my attorney. And that's essentially what it does. It's a very small number, and I only charge $100. It's only for Texas. Yes, it's only for Texas. Now, you can also get it for federal issues because I can practice in federal courts anywhere in the country. I just have to, if you're outside of Texas, I have to do what's called a pro hoc vice. It's a pain in the ass because I got to find another attorney that will sponsor me in that other state outside of Texas. And by that time, you really don't want to hire me outside of Texas because it gets expensive because I got to travel. So generally, that really only applies to Texas is the 500. And again, that's just a general sort of send me an email if you got a legal question, send me a phone call if you got a legal question. I log all that time. I let you know if you use it, I let you know, hey, you're coming up on your 5 hours, that 500, you can do another retainer. Most people, what they do is they just do the $500 retainer and they don't use it because they don't really have to. But then if there's like a civil or a criminal case later, and let's say my retainer is X dollars, I'm just going to throw a number out there. Let's just say my retainer's $3,000, right? Then if you've already got me on a $500 retainer, then that is added to that. So really you only have to come up with $2,500. If it's a $10,000 retainer, you only have to come up with $9,500 because you've already got me on a $500 retainer and you haven't used any of that. That's how I work that. It's probably the cheapest you're going to find anywhere other than, someone that's maybe your family that will just say, yeah, just tell them I'm your attorney. So how long does it last? It literally lasts until you use it. Because I keep it in a trust and, as you use it, it just kind of stays there. Now I don't have to keep it in a trust because I've already earned it. The fact that I'm on call, means that I've earned that. But what I like to do, and here's why I do it this way. I keep a lot of money in my trust account because, when a client pays you for a case, and by the way, for those of you, this is the end of the presentation. You can just leave if you're done. As a matter of fact, I'll even just stop sharing this because we're done with that. What was I saying? I forgot what I was saying now. I forgot what I was saying because I was getting rid of everything. Retainers. So when an attorney takes a retainer, and this is also what annoys me about a lot of attorneys, is I do things with a flat fee. And because I realize that a lot of people, if we did it by the hour, it would get pretty expensive, for a lot of people, and it would go beyond what they can afford. But let's say I charged you $10,000 to argue a felony case on your behalf, right? That you hired me because you were charged with a felony. Felonies are very difficult. They're very complex. They take a lot of planning and preparation. And not only that, but, you're talking years in prison if you're found guilty. And so there's a lot of stress and a lot of burden that comes along with that as an attorney. So let's say I charge you $10,000. Hey, look, I'm going to take this case. It's $10,000 or $5,000 for pretrial. If we have to go to trial, it's another $5,000, that kind of thing, right? And I get your $10,000, and in about a month, I get it dismissed. And my flat fee, and a lot of attorneys, they put this in their contract. It's in my contract. Look, this is a flat fee. And this is what I'm charging you for this case, no matter how long it takes or how little it takes. But ethically, I can't do that. Okay. Now I know that the way that the court system works, and I charge very little anyway, I'm going to eat through that. But if I take $10,000 from you and I only do $1,000 worth of work, I am ethically obligated to give you a refund, even if the contract said no, because it's not reasonable. It is not reasonable for me to do 2 hours of work, file a motion, get your case dismissed, and I get to keep your $10,000 for all of 3 hours of work. Okay. It is not ethical. And if you come across an attorney who does that, who takes your case for $10, $12, $15,000, and then, you know, after a month or two of, you know, maybe showing up for a couple of hearings, filing a motion, get your case dismissed, you should demand a refund. And if they don't give you a refund, you should go to the bar and complain about the fact that he's taking money he hasn't earned. Now, if the fee, there's, you got to look at the contracts, okay? Make sure you read the contract. I sit down and explain every paragraph to my clients. Read the contract, because sometimes the contract says you're paying me $10,000 to get this dismissed, whether I get it done in 10 minutes or not, because to you, getting this dismissed is worth $10,000. So yeah, obviously there are exceptions to that. This is not a blanket rule that just because someone charges you $10,000 and it's over with in a month or 2 weeks or whatever, that they owe you money back. Look and make sure the contract doesn't say you're essentially paying me $10,000 to get this case dismissed. Because if that's the case, then what you're saying is it's worth $10,000 for you to do 2 hours of work and get this case dismissed. All right. All right. So there's that. Let's see. I think that's pretty much everything. Hey, Billy the Kid. Yeah, I'm glad you're not in trouble. A lot of people, you know, it's the reason I use self-defense fund. You know, I don't plan to shoot anybody, but you just never know. And I've been falsely arrested 4 times. So I know that you can be breaking absolutely no laws and still get arrested. And you're going to need an attorney. Do I have a network of contact in other states? In some states I do, and I'm starting to build a network. As a matter of fact, I just got approached by one of Kyle Rittenhouse's former attorneys about a potential J6 case that we're going to work on together. And so I'm building that network because there aren't that many of us that are willing to. There just aren't that many attorneys that are in this for the right reasons. And what I mean by that is literally in it for justice and not as a way to get rich. And trust me, you can ask my wife, we're not getting rich. Yeah. So, anyway. All right, guys, that's all I've got for you. Let me see if, nope, no, that didn't upload. I think what I'm going to do is I'm going to just put that little 17-second video that I created of my logo. Maybe I'll just put it up as a separate video, but it'll eventually take the place of my normal intros. All right, guys, you guys take care, be safe, be free, and I'll talk to you next time.